Good evening, I'm Maria Aguilera. Thanks for joining us on KHOU 11+. Tonight we're answering your questions as a renter in Texas. Eric Quatler with Lone Star Legal Aid is here to provide valuable insights to help us understand your options. Now the goal is to show you how to effectively manage a range of issues you may encounter with your landlord. Eric, now we do have a few questions, but first let's start with what are the main 3 issues you see as managing attorney of the eviction right to counsel unit?
So number 1 is obviously eviction, right? Which is a complicated subject that a lot of people have questions about. And the most important thing to remember about eviction is that you have rights. You don't necessarily need to self-evict if you get a notice. And you should absolutely call Lone Star Legal Aid if you're facing eviction. We can see if you qualify and see if we might be able to help. The other 2 are repairs that need to be made and lockouts.
Okay. And that's kind of the main things that you guys see, right?
Yeah.
Okay. And so now we do have some viewer questions, and I think it's important to note that you said a lot of these questions and the answer to these questions are not going to apply to everybody, right? It's case by case.
That's right. Yeah, and it's important to understand, I'm here to provide legal information, and I'm happy to do that. I'm happy to share that expertise with everyone so everyone knows their rights, but this may not apply to your specific case, and it doesn't mean I'm your lawyer. But if you are interested in our services, by all means, give us a call or go online. There'll be information at the end of the broadcast about how to do that, and we'll see if we might be able to help.
Yeah, and with that being said, we'll get started with some of those questions. We have a viewer who contacted us and said that if their contract says that they don't pay rent by the 10th of the month, can their landlord lock their door? They said, I did sign the document when I moved in, so is this legal that my door can be locked on the 10th if I don't pay rent? What does the law say about that? About the landlord holding your belongings after you have moved out and they changed the locks and did not answer your phone calls? Okay,
so lockouts are a great place to start, and because it's a way for me to explain a little bit about the law and some of the things I'm going to say. My dad has a saying, locks are meant to keep honest people out. If a dishonest person really wants to break into your home, they'll break the lock. The same is true with the law. The law is not a force field. The law is a set of consequences, which means that if a landlord does something that's illegal, it means that there may be negative consequences for them. It does not actually physically stop them from doing it. So if I say a landlord can't lock you out, it's not literal. They can, and they may, but there are consequences, and I'm happy to talk about those. In Texas, you can lock someone out of their apartment if they have not paid their rent. However, they have the immediate right to a new key, and that key has to be provided 24/7. So lockouts, if done right, are more bark than bite. But it's really important to understand that no matter what your lease says about lockouts, this is true, that if you get locked out, you contact your landlord and say, I want a new key. Now, if they say no, which they might, right, at that point, you may need to see a judge, and I recommend calling Lone Star Legal Aid, and we can see if we might be able to help you. Additionally, lockouts aren't always literally changing a lock, right? Some landlords will use what's called a key block device, which is essentially a hard rubber thing that they put around the doorknob that makes it impossible to turn the doorknob. It's a lot cheaper because they're about $20-30 and they can reuse them. So just when we say lockout, it doesn't necessarily mean that they've changed their locks. It means that they have excluded you from the premises.
Okay. And now moving on to another question. So this person says, what is the reasonable amount of time for an apartment complex to fix a leak and mold issue? You said that that's something that's common as well. On a second note, is there any sort of limitation on the amount of time that has passed since you moved out of a previous apartment with the same issues I'm experiencing now with the leaks and the mold?
Sure. Yeah, repairs are a huge part of what we see. Part of that is because it's very difficult to enforce your rights to repair in the state of Texas. Obviously, there are ways that you would normally request a repair. Usually call the landlord, right? Use the resident portal, whatever the instructions are from your landlord. And you should follow them. You should do that. But doing that is not going to be enough to force the landlord to make a repair. The only way to force a landlord to make a repair, and that's possibly getting the constable to come out and tell them, make the repair, you're going to jail, is by sending them a certified letter. Now, if you don't know what that is, that's okay. You can go down to the post office and say, I want to send a certified letter, return receipt requested, to my landlord. And in that letter, you should say, these are the things that are wrong, and I need you to fix them as soon as possible. You should be as explicit as possible so they know what's going on. Once you've done that, the law actually talks about what how much time is presumed to be okay, and it's presumed to be 7 days. However, those 7 days can be shrunk or expanded based on a number of factors. For instance, there are some repair conditions that are quite immediate, like an overflowing toilet, right? Where if you waited a week, then the entire apartment would be destroyed. While there are others that may require materials to bring in, things that may be difficult to get, or it just may take longer to do. But the presumption is 7 days. So hopefully that answers your question. Remember, certified mail if you want to actually get your landlord to make the landlord do what they're supposed to do. Also, if you send that certified letter and wait 7 days, you have the right to cancel your lease.
Yeah, and that's really great information because we have had viewers reach out to us asking stuff that's similar to this and wanting help. So this is something that a lot of people can, relate to. And now, we just got out of this winter storm and this cold weather event. So I do have a question for you, specifically when it comes to AC, heater, plumbing issues, etc. So who actually holds landlords accountable to timely resolve these issues, and who can renters contact with these issues if they do have these problems?
Yeah, so there are a couple of answers. One of them is us, right, is attorneys who take this kind of work, because the one way to hold the landlord accountable is to go through the law, which involves possibly suing them and, like I said, possibly getting the constable out to fix it, or it might also, in some cases, involve further damages against the landlord, money or other things. So that's part of it. But also you can call the city, and the city will come out if there's a code enforcement problem. And in a case of, for instance, a really massive problem, they may even red tag the unit. So definitely an option. And keep in mind that you have the absolute right to call the city. And if your landlord then attempts to evict you for calling the city, that's retaliation, and they can't do it. Again, they can in the sense that they might try, but legally they're not supposed to.
Okay, just because they can doesn't mean they should, and then you have your rights to reach out to the city in order to get that fixed. Okay, so we have another question, and it says, a fire started in my apartment in another unit above me that caused the sprinklers to go off in my apartment to flood. What will happen? Who will be responsible to cover those damages?
Okay, so part of the answer is it depends on who started the fire, right? But it shouldn't be you, unless you started the fire, but probably unlikely. So it's not going to be you. It's probably going to be either the landlord or the tenant who started the fire. However, keep in mind that people don't have infinite resources, right? Especially renters. Most renters live paycheck to paycheck. That doesn't necessarily mean you're poor. It just means that you don't have a lot lying around, right? So if someone comes in and says, I'm going to sue you, well, you can try, but you can't get water from a dry well. Right, there's a piece of paper, a judgment, is not very useful to someone who, against someone who has no money. So that's why it's really important, if possible, to get renter's insurance yourself. That way, just in case something like that happens, your renter's insurance can be the ones who deal with it. So I definitely, sometimes it's as low as $50 a month, which I know for a lot of people is a lot of money, but you can look around and see if there are other cheaper plans depending on how much you have in your apartment and the size. So definitely recommend that. The other thing I'm going to talk about real quick is what we call casualty loss. So a casualty loss is essentially a serious habitability issue caused by something that is out of anyone's control, like a hurricane, right? It's usually a disaster. But it could also be something like what this questioner was talking about. And in that case, if the unit is totally uninhabitable, then you have the absolute right, and so does the landlord, within 7 days to say, you know what, I'm not going to live here anymore and you can't charge me any more rent. So if you can't live in the place because of whatever happened, keep that in mind, that the landlord can't keep charging you rent if you say after, with a week's notice, I'm done, I can't live here anymore, everything's wet, there's mold, I gotta go.
You mentioned renter's insurance.
Yes.
Not every apartment complex or landlord requires it, but talk to us about the importance of it and how that plays a role. You mentioned that a little bit because although $50 may be a lot for some people, they can end up paying a lot more if they don't have things covered, right?
Yeah, and especially if there are things in your apartment that have fiscal value. Everyone has things that have value to them, right? And it's important to preserve those when we can. But they may not have a lot of monetary value, and unfortunately, a renter's insurance policy can't bring back photo books and things like that. But if you have personal property that has some value, a computer, a TV, things like that, and a lot of people do, then it's good to have renter's insurance to protect that property. But it's also good because renter's insurance may be able to help you if you are displaced from your unit. So yes, there are a lot of different policies. Shop around. You can do that online. Some of your apartment complexes probably require renter's insurance, but not all do. And you can get it for a house too, not just for an apartment.
And this viewer question actually really stood out to me. So this viewer says, I'm a renter, and for the last 7 months, I have been dealing with a large sinkhole in my front yard. Management is aware and has done nothing to relocate us. It is affecting the foundation of the home, estimated 20 feet deep, that's pretty big, and growing by the day. Now, do I have to keep staying here and paying rent?
Okay, landlords, don't sabotage yourself. If you've got a big hole in the front yard that's destroying your property, it's your property that it's being destroyed. And eventually you're not going to be able to make any money off that property. Fix stuff like this. But you can use the certified mail process that I was talking about, because the standard is that the condition has to, or would have to, materially affect the health and safety of an ordinary tenant, which is legalese, I know, but it basically means if it's dangerous, then it needs to be repaired. And I would say a 20-foot hole in the front yard is very dangerous. It's also a potential liability issue for the landlord. If, God forbid, a neighborhood child came by and fell in the hole, they could seriously injure themselves, and none of us want that to happen. So the answer to the renter is, yeah, send that certified mail, and if they aren't going to fix it within a week, then you can bail.
Yeah, and like you said, I mean, that could cause some serious dangerous situations
Yes.
for not only themselves, neighbors, and for their property too. Okay, so another question, and this one kind of goes along with the lines of lease, right? Everybody's lease is different, but this one person says that they are buying a house in March of this year, but their lease doesn't expire until August of this year. So is there any way to get out of that?
Okay, so the truth is that almost everyone's lease is the same. There's a Texas Apartment Association lease and a Texas Association of Realtors lease, depending on whether you live in an apartment or a house. But that doesn't mean that there are no addenda. That doesn't mean that you should always read your lease. You're probably not going to have any opportunity to cross anything else, but you should always read it. And the answers to this question are going to be contained in your lease, because the lease will almost certainly say, if you want to leave early, then these are the consequences. And a lot of the times it's just a cash payout, sometimes 2 months rent. Just say, pay us 2 months rent and you're free and clear. But you got to be careful, because if you're not careful, you can end up paying rent for months that you're not there. The landlord has what we call a duty to mitigate, which means that they have to try and relet that apartment or that house immediately, as soon as they can. So you're off the hook. But that doesn't mean they'll be able to. So be careful when you're breaking your lease. The number one piece of advice I have for you in almost all these things is talk to your landlord. Talk to your landlord and see if you can work something out, because it might be that the landlord wants to take advantage of you leaving to raise the rent on the unit, or if market conditions have changed. So you might be able to work something out that's not as unfavorable as you might expect.
Especially if they've been living there quite a while and they
Yes.
have a certain deal, and they want to actually get more by somebody else coming in, they'll benefit.
Yeah, I mean, these things change all the time.
Okay. Next question. So this person says, I live in a gated community with a garage. However, the gate is constantly broken. This is something that we get often, especially about apartment complexes. That has led to their car being stolen, broken into, and their tires being stolen as well. This person says, I don't feel safe, but my apartment wants to charge me for breaking my lease. What can I do? Am I able to break a lease if the apartment management is not doing anything regarding the numerous break-ins? Or do I have to, and if it's creating an unsafe environment, is what they said.
Yeah, I have some bad news. Unless it otherwise says, which it won't, there's no warranty of security in your lease. Basically, the cameras, the security cars, the gates, it's all theater. It's all an illusion of security. And thus, you can't rely on it. I can tell you that I had my apartment broken into years ago because the gate was broken around the holidays. It happens to a lot of people. And unfortunately, it's very difficult to hold landlords accountable for that. So the answer is unfortunately probably not. If your landlord is being that way, sometimes there's just nothing you can do about it.
And this seems to be a common question because we've actually received some emails in the past from people dealing with their tires being stolen at their apartment complexes, and the main thing that they always say is, but we are supposed to have security, and they're not there. We're supposed to have our gate operating and it's not working, or we have cameras but they're not actually recording and they want to do something about it, but then the management company or a complex or the landlord just says, hey, there's nothing that we can do about that.
Yeah, and your lease may also have something that explicitly says this, that says we may have security measures, but it is not a promise that they work.
Oh, wow. Okay. Another question, okay, says my lease ends soon, and despite the fact that I have reached out to the apartment complex multiple times, they refuse to send me the offer for a new lease. I'm required to give 60 days notice, which would be in a few days. Can they keep ignoring my request for a lease offer?
Yeah, so what I would recommend is that you keep in communication, and that even if it's one-sided, you provide what you need to provide. So the consequences of not providing that 60-day notice are that you could still be obligated under the lease at the end of the term. So if it's a year term and you're 2 months out, 60 days, then after the year, your landlord could say, well, you didn't give notice, so you still have to pay your rent. And the bad part is a lot of these leases have month-to-month rent that increases by up to a few $100s. So you could end up being obligated to pay a higher rent if you don't give the notice as required under the lease. So give it, but you can say, look, I'm going to terminate my lease if I don't get another offer, right? If you give me an offer to sign a new lease, then great, then I'll consider it, right? You can always do that. Right, you can always sign a new lease. You can sign a new lease in the middle of the term of your lease if you wanted. So I would say just keep those lines of communication open, and at the same time, do what you need to do to protect yourself.
That's the biggest thing, is protecting yourself, having things in writing, timestamps, things like that, to make sure that you've done the work to reach out and make an effort to try to resolve that.
Absolutely.
And we have a final question. It says, when an appliance goes out in an apartment, should we replace with the same quality that was in your apartment when you rented it? An example of it came with an ice maker. Should the new one have an ice maker? I assume they're talking about a refrigerator.
Yeah, there's almost certainly no guarantee that that's going to be the case. Now, I can tell you that most apartment complexes are owned by very large corporations, and they use the size of the corporation to create economies of scale. Basically, they get stuff cheaper because they buy a lot. And so a lot of the stuff is going to be the same. So usually you're going to get something as good or better, but it's not necessarily a requirement. And certainly something like an ice maker, there's no guarantee that, unless you have an addendum to your lease guaranteeing an ice maker, which would be quite strange, then you're probably not guaranteed one. That's the problem, with apartment fixtures, that it's also harder to demand that they be fixed because it may not be a health hazard. So unfortunately, the answer is no.
I can see why somebody would think that having something before, you'd want to have the same quality,
Absolutely.
But it's not. They don't have to do that.
Yeah, and I understand, because you moved in because you saw the fridge with the ice maker and said, I want an apartment with an ice maker, and then suddenly they do the bait and switch. And I understand why that would be frustrating, but it's not something that's very easy to handle.
Okay. And Eric, we actually got a few more questions. One of them there, it says, is an email a legal form of giving a 60-day notice if the leasing office responds?
Okay, so it's kind of unclear when we're talking about a notice that you're not going to renew your lease. It's better to do it in writing as well. Email's great because it's trackable, right? Really easily. You don't have to pay extra to track an email. But if you're ever unsure that the landlord is going to honor that, then you should find the place that you pay rent, whether it's the apartment complex office or the management company or the owner of the unit, and give them a piece of paper that says, I'm moving out of here.
So this is one of those rather be safe than sorry.
Yes.
And just, although you responded to the email, just go ahead and get it in writing. And that's going along the lines of what you said, protecting yourself.
Absolutely.
Okay. So another person wants to know about violations of the ADA laws for renters with service animals, and can you sue the landlord for the violation of it?
Okay, so this is a complicated topic. The law in this area is called the Fair Housing Act. Actually, the ADA applies to places like restaurants and businesses. We call them places of public accommodation. But for your home, it's a little different, and you have more rights. Under the Fair Housing Act, for instance, emotional support animals, not just service animals, are covered. And yes, if a landlord refuses to allow your service animal, you might have rights. The way this works is called a reasonable accommodation. A reasonable accommodation is an interactive process between you and your landlord, you saying, I have this problem, and this is what I'm saying I need to fix it, right? In this case, I need the emotional support animal, and here's my documentation, etc. Service animals and emotional support animals are not pets. They're not, they're tools, right? Just like a wheelchair. They ameliorate a disability. So it's important to know that if you have a service animal or an emotional support animal, you're not supposed to be charged pet rent. They cannot, and again, cannot, right, prevent you from having an emotional support animal. They cannot discriminate based on the dog breed, for instance. They can't say, yes, you can have an emotional support animal, but it has to be under this number of pounds. There are other considerations for that, obviously, but the answer is yes. You can also file a complaint with the Department of Housing and Urban Development. But if you're having a problem, I suggest you contact either us. You can also contact Disability Rights Texas, and either of those organizations can see if you might be eligible for their services, and they might be able to help you.
That's good to know. A service animal is not considered a pet.
Absolutely not.
And so it shouldn't count as that, and they shouldn't be charging you.
That's correct.
For a pet fee. Whereas anybody else, like I have a dog, and they will charge me for the pet rent every month. That's completely different.
Yeah.
Okay. Another person asked, is there a way to get out of my lease and recoup some moving and living costs since the apartment I'm paying is over $1,500 a month and it was not in the state I was promised?
Okay, so it's kind of unclear from the question whether the apartment or the unit was that way when they moved in, or whether it has deteriorated, and those are different questions. But the answer is probably no. Yeah. The answer would only possibly be yes if there were something very specific that was not there that was supposed to be. Or, for instance, they moved you into a 1-bedroom instead of a 2-bedroom, right? And they tried to charge you the same rent. That's not okay. But generally, no. A lot of people see a bait and switch in their rentals, unfortunately, and there often is just not very much you can do about it.
I have a question along those lines, because I know that there are some apartment complexes that have that may be older, right? And they have maybe a half of the apartment complex is the older models, and then they've renovated and renewed the other models. Could that apply in that same aspect if they toured maybe a newer model and they thought they were getting that one, but they're actually being put into an older one?
Potentially. A lot of this is so specific to the lease and so specific to the complex that I can't really tell you.
It's case by case.
It is, and apartment complexes will often have classes of apartment, and you could say, okay, I was supposed to get a Class D apartment, right? That's just like the not necessarily hierarchy of good, but just it's the Class D apartment, and they put me in a Class F apartment. Well, and look, this is the website, right? The Class D is supposed to be this price, the Class F is supposed to be this price. At that point, there are certainly things you can do. And you can also always call the Better Business Bureau or things like that if you're having a problem with a company, right? They may not do anything, but use the power you have as a resident and as a consumer.
We kind of talked about this a little bit, but I think this is kind of a broad question. They're saying, how should a renter deal with eviction?
Oh, okay. Well, so as I said at the beginning, my first piece of advice is don't panic. It's important to understand what an eviction is. An eviction is a lawsuit. So just like a personal injury lawsuit or anything else, that you have to sue someone, they have to get served by the constable, and at that point there's a trial. And the trial goes through, and then if the landlord wins, at that point there are steps they can take to get what's called a writ of possession, which is the document that allows the constable to come and put you and your stuff on the curb. So it's a long process. So if you get, the first step of that process is a notice to vacate. And usually they'll be 3-day, but they could be really anything between 3 and who knows. Every once in a while you have one that's 1, but regardless, they're going to tell you that, okay, you owe this much money, or we don't like you for this reason, right? You violated the lease somehow, and so we want you out, and you have 3 days to get out, or else we're gonna evict you. Okay. Unless you have a really, really good solution on the spot, don't do it. All right, because you're going to be on the street, and you'll have had no opportunity to engage in the rights that you have as a renter and someone facing eviction. So self-evicting is generally not a good idea. If you're facing eviction, then I do recommend that you call Lone Star Legal Aid. We may not be able to help. We have our own, qualification standards, and we can only help so many people. But we definitely can't help you if you don't call us.
Yeah, and that's it for all of our questions. Do you have anything else that you'd like to add? I know that some of these questions that were asked help a lot of people, right? Because they were very vague, and a lot of people have dealt with some of these issues, but some were very specific. And I'm sure there's people even watching this that have very specific questions. What do you recommend for them?
Yeah, so I recommend always, when you're having a dispute with your landlord or you want to assert your rights, the first thing you should do is just try and talk it out. Because people are reasonable, and you may be able to come to a compromise that works for everyone. Not always. Sometimes landlords will be obstinate, will be stubborn and say, no, we're not doing this, we're not going to do what you need us to do. And sometimes that may be a very, very grave situation for the renter. If, say, we've seen a person who requires a ventilator have the landlord turn off the power to their apartment, things like that. It happens. We don't like to think about people doing things like that, but it does happen. And so it's important to first try and talk to your landlord. If that doesn't work, then you may need someone to intervene on your behalf. But you can also go down to your local justice of the peace court and talk to the clerk and say, I need to do this. I've been locked out, I need to get back in. I need a repair and they're not doing it. Or they've cut off my utilities and I need to get them back on. And they'll have forms for those things. So even if you're not able to get help from a lawyer, you can do it yourself.
Yeah, and I think many of us have been there at some point needing some kind of assistance or having to deal with something with management or your landlord. And I think we actually have one more question. I think our producer is asking, can a landlord evict you for a past due bill?
Okay, so it depends on the bill, but the way this usually works is the landlord decides how they're going to apply your rent money. So they'll say that even if I can't evict you for a $50 amenity bill that you didn't pay, I'm just going to take $50 off your rent and I'm going to pay the amenity bill. So now you're $50 behind on rent and I can evict you for that. So yes, essentially yes.
That's good to know. So I think the key takeaways out of this, right, is try to talk to your landlord first, right, and your management. Mm-hmm. If that doesn't work, try to seek out and get help, right, legal advice, and go somewhere that is going to give you professional help. Is it the best to try to have proof, paperwork, things to prove what you're trying to prove, and
Always.
do things to just overall protect yourself, right?
Absolutely.
Do what you can to protect you. Is some of the key takeaways. And
if you're having a tense relationship with your landlord, then if you interact with them and say, give them rent, always get a receipt, right? If you need to memorialize your conversations with them somehow, just make sure that you say, okay, I want that in writing. They may not give it to you, but they may use email, right, instead of a phone call, because email is trackable and proof, it's on paper. Anything that or text message too, any of those things is better than just a phone call. Yeah. So try and keep track of all your records.
Just don't take their word for it. Have things in writing, I think, is really important.
Trust but verify.
Yeah, okay. Well, if you need further assistance, you can apply for free legal services. You just have to call 1-800-733-8394 or visit lonestarlegal.org. Eric, what type of legal services does your organization offer?
Yeah, so we represent low-income individuals throughout the Southeast Texas region, including Houston and the surrounding counties, all the way up to Paris, Texas. And we offer obviously housing services like what I do, but also family law, public benefits. If you're having a legal problem that isn't criminal in nature, then you can definitely call us and we can see that if you might fit into one of our practice areas. And again, you definitely can't get help if you don't call.
Perfect. Thank you so much, Eric, for joining us and for all the information and help. I'm sure this is really helpful for a lot of our viewers, especially those who sent us these questions. Now, we hope that this Q&A helped you understand your rights as renters. You can watch this entire stream whenever you want on demand on KHOU 11+.